My name's Louise Hooper. I'm a member of the immigration team and I'm chairing this meeting. So firstly, for some housekeeping, the meeting instructions are that you've been placed on mute. The most important thing is that if you have any questions, can you put them in the Q&A, which you'll find in the centre at the bottom of your screen. If the last year of dealing with Zoom meetings hasn't already taught you that. Resources, we ask you not to post in the chat function questions. But feel free to put comments, queries or feedback in the chat. Resources will be circulated to delegates after the webinar. The webinar is being recorded. That means that the audio and video of the panelists and anyone who speaks, if they're unmuted, will be recorded. The webinar may be shared on our marketing channels, including our website and social media. Please refer to the instructions in the chat window if you're experiencing technical difficulties. So the purpose of this seminar is to consider the recent decision of HA Iraq, which in turn considers the Supreme Court decision in KO Nigeria, in which Sonali, Naik QC and Helen Foote acted. We're going to take a look at what the requirement to take a child-focused approach to unduly harsh in a deportation context means. HA Iraq represents a departure from previous authority that seemed to suggest that if the effect of deportation on children was seen as no more than what would ordinarily or necessarily be expected, that could never be sufficient. And this is one of the reasons that we think we have to be cheerful. The speakers will consider how the principles in HA Iraq can assist practitioners who represent appellants in deportation appeals. And also at the end, we're going to consider very briefly whether there's further scope to ensure that British children and children with long residence can ensure that their rights to family life are properly safeguarded in cases where a parent or caregiver is being deported. At present, all of us on the panel, alongside Grace Brown, who's not with us today, are involved in ongoing litigation relating to the Jamaican charter flight in December, which concerns variously the rights of children in deport appeals and the rights of children, young adults who came to the UK as children. As an aside, I'd also like to draw everyone's attention to the literature review that was produced by Bail for Immigration Detainees in November 2020, called The Impact of Forced Family Separation on a Child, which provides a literature review of academic evidence and other evidence of harm caused to children by family separation in the context of both imprisonment and deportation. It's a detailed assessment of the types of harm and the long-term consequences to children's health, welfare and development, which is obviously all very relevant to the assessment of child's best interests. And as I say, links will be sent out after the webinar. The structure of this seminar is that firstly, Sonali will do an overview of KO and children's rights principles. That will be followed by Helen addressing the HAAA-KB line of authority. And then finally, Zara will talk about deportation appeals in the first tier tribunal and best practice. Sonali will sum up at the end, looking at the wider issue of children's rights in deport appeals, including the approach to the assessment of their rights independently from that of the deportee. So after that introduction, I'm going to start with Sonali Naik, who is a senior public law and immigration practitioner who probably needs little introduction to many of the vast number of people in this seminar. Welcome to everybody. She's ranked for Immigration in Chambers UK 2020 and has significant higher courts practice. As mentioned, she was involved in the Supreme Court case of KO Nigeria and is frequently instructed in Article 8 cases, certification challenges, nationality challenges, and deportation cases. She's chair of Liberty and a trustee of Freedom from Torture and the Immigrant Aid Trust, which is the charitable arm of the JCWI, and was appointed to the Justice Working Group on Reform of Immigration and Asylum System. She's won a variety of prestigious awards, was finalist for Legal Aid Lawyer of the Year in 2016, and has also been featured as the Times Lawyer of the Week and is now looking suitably embarrassed. So without more ado, I'll hand you over to Sonali.
Right, thank you, Louise. I hope you're going to stop at some point. Right, I am sharing my screen. You just confirm that you can see that? Yes? Is that right? No. Yeah, you can see that screen, right? Yeah, great. Okay, thanks very much. Yes, I am slightly embarrassed by Louise's long-winded introduction, not least because possibly because of the result in KO Nigeria. So one of the reasons that Helen and I and Azera want to do the seminar, particularly Helen and I, was that after KO Nigeria, we did really need reasons to be cheerful. And it's not just that we're massive fans of Ian Drury and the Blockheads. So, as you know, I'm going to talk you through KO just in brief terms, but the reason KO Nigeria needed to be heard was because we were at the point where the court needed to consider how to implement or how to analyse. Oh, you could see the screen, but you can't now. Sorry. Just bear with me a moment. Sorry, can you see the screen? Right, okay. Okay, hopefully you can still see that. Right, please do tell me if you can't. The court needed to analyse how the statutory public interest considerations which were introduced by the 2014 Act played out in the context of deportation, and particularly in the context of how to assess best interests of children. So I've just set out there for your reminder what the statutory public interest considerations said in respect of deportation. And you can see there the reminder of the principles that deportation of foreign criminals is in the public interest. The more serious the offence committed, then the greater the public interest in the deportation of the foreign criminal. And in the case of a foreign criminal who hasn't been sentenced to a period of 4 years or more, the public interest requires the person's deportation, unless one of the exceptions applies, exception 1 or exception 2. And we're particularly here, of course, concerned with exception 2, which is in relation to where a person has a genuine and subsisting relationship with a qualifying partner or a genuine and subsisting parental relationship with a qualifying child, and the effect of the deportation on the partner or child would be unduly harsh. Now, we all know as well, I don't think I've put this slide up, that there's another section, section 117C6, which is if you're over and above that, then that threshold, then you need, in terms of the 4-year sentence, then you need to show very compelling reasons. And just to finally put this in context, of course, KO Nigeria, in the linked cases, was also concerned with the test in 117B6, which was removal cases, and the difference between the two tests. And I think that, in my view, because this KO Nigeria was linked with 4 other cases or 3 other cases, that seems to be, to my mind, one of the reasons why the case didn't examine the principles in the depth that it could have done, because in fact the court was more hamstrung by the statutory construction of section 117B and section 117C, and didn't really get into the nuance of what it really needed to look at. The other thing I'd like to bring to your attention, and this for me is a really important principle. I don't know if it was cited in HA, I'm sure Helen will remind us, but when the 2014 Act was being introduced, and introducing those provisions which I've just looked at, 117B and C, section 71 was introduced, and it said, for the avoidance of doubt, this Act does not limit any duty imposed on the Secretary of State or any other person by section 55 of the Borders Act 2009, i.e. the section 55 duty that we know so well. And that's critically important because unless Parliament had given it that authority, then all of the principles that we know in relation to the assessment of best interests, all of the law on section 55 and how it's implemented, that's all still there unless Parliament had made a change. It did not. And that's what I think is really critically important, that when the UK Borders Act introduced automatic deportation in 2007, and then when the reservation on the UNCRC principle in relation to best interests of children was lifted so that it was directly implemented in the context of immigration, there's nothing in the Act that limits that duty. And that, if you keep that principle in mind, which I don't think the Supreme Court did, but perhaps if they didn't, it was our fault for not making sure that they did, then I think that other things and other principles fall into place. And so I just emphasise that section, because as far as I can see, there's no reported case on Section 71 or reference to it anywhere. So just skipping ahead to the problem that Lord Carnwath, we say, created in KO Nigeria. So just remind you that in KO Nigeria, the appellant, I think, had won at first instance, certainly won, and then in the upper tribunal, they said, well, if we were applying a balancing exercise, then we might dismiss the appeal. But if we were just focusing on the impact on the children, then we would allow the appeal. And that was the view of the upper tribunal. And that was ultimately the principle that the Supreme Court had to examine. And it went from the Court of Appeal dealt with it very briefly, and in the Supreme Court that was the question. And the Secretary of State's argument was not accepted by the court. Effectively, the court said, we're not concerned with a balancing exercise. The assessment is really just about what is the impact on the child. So in legal terms, we clearly, in my submission, in my view, of course, my submission was that they didn't accept that. We should have won our case on the facts. We won our case on the law, so that the argument about the balancing exercise was rejected, but we lost our case on the facts. And with it, or in the way in which we lost our case on the facts, was because of the way in which Lord Carnwath seemed to express himself in relation to what did unduly harsh really mean, and how should it be applied here. So again, remembering that this is not a balancing exercise, but in terms of the conduct of the parent, what he said, and this is most of what needs to be analysed is in paragraph 23 of his judgment, is that unduly harsh seems clearly intended to introduce a higher hurdle than that of reasonableness of removal. Well, we could accept that, or maybe not a higher hurdle, but a different hurdle, bearing in mind that in removal cases, you're deciding should the family, effectively, quite most often, is the family unit going to stay as a whole or go, and should you require, and what are the interests of the children in that context? Whereas in deportation cases, the examination is whether the family can go as a whole, or whether the public interest dictates that the family should be split. And that's often, of course, the situation in the scenario that we're dealing with. And so it's a different test because of a different context. Whether it's higher, and it may even be higher, is not a complete answer to the application that Lord Carnwath seemed to give it here. He then referred to unduly, implying an element of comparison, and suggesting that there was a due level of harshness which was acceptable or justifiable in the context, which is very difficult to unpick, certainly on the facts of the case in KO, and very difficult to understand when you're trying to apply that to other, when you're running in first instance appeals and so on. And unduly harsh, he says, is looking for implying something that goes beyond that level. And this is the passage that's caused us such a lot of difficulty, where he says one is looking for a degree of harshness going beyond what would necessarily be involved for any child faced with the deportation of a parent. Well, it's pretty impossible to know what that is, because in some cases it's a stay scenario, some cases it's a go scenario. The only qualifying criteria to engage this section is that you are a qualifying child, i.e. either a British citizen or a child who's lived in the UK for 7 years, who has a genuine and subsisting parental relationship with the deportee. So again, very difficult to understand. And none of the case, what the submissions in court were not focused around this. We were focused around the legal test and not how to apply it in the sort of nuance and contours of the facts. And the one thing I would just add is that importantly, and this we'll see when we come on to look at HA and Zara's presentation as well, is that there was no expert evidence before the tribunal in KO. So they didn't have any evidence about the impact on the children, aside from what they themselves said, or what was said on their behalf by their parent or parents. And in my view, that's a really important consideration, because it demonstrates the evidential vacuum that existed for when the Supreme Court were looking at the case. So the important thing, we say, is that the KO Nigeria reached the conclusions that it did. But the first thing that Lord Calmwood did was set out all the principles in the extant case law in relation to in relation to how to interpret Section 117. They're supposed to be consistent with the general principles relating to the best interests of children. That a child mustn't be blamed for matters for which she's not responsible, such as the conduct of the parent. That's what you get from Zumbas. And importantly, some of the principles that we heard over the years from Baroness Hale, in various cases, including ZH, I'll come to in a moment, McLoof, was that children are human, but they're different human beings from adults. They have developmental needs which someone must meet if they're to grow up into healthy, functioning adults and fit to play a proper role in society, i.e. they need parents and parental involvement where that can be shown to be positive, or certainly definitely not shown to be negative. Children must be recognised as rights holders and not just as adjuncts to other people's rights, and that their best interests must be treated as primary consideration and considered separately from those of adults involved and from the public interest. Now that is a passage from the Supreme Court decision in McLoof, where the principles were considered, but very briefly. This was a case that was heard at the same time as Hesham Ali back in 2016, and unfortunately in McLoof the context was that the fact that there was a finding that there was no effectively genuine parental relationship between the father and the children. They were his children, but he had a family court had already found that there was no it wasn't in the children's best interest for him to have contact with them. So it wasn't an appropriate vehicle to examine the application of the principles of best interest in the context of deportation. But at least Baroness Hale, and there's also a concurring judgment from the late Lord Kerr, where he also emphasises the same point. And I think those what my principal points is that those are still absolutely live and valid, and there's been, of course, no overturning of that by KO. I also just refer again to Baroness Hale's reference in the HH case, which this is an extradition case, but it's again another important part of the contextual analysis of how to interpret children's rights. Children need a family life in the way that adults do not. So all of the family life cases on adult relationships are very different from the needs of children and how those principles should be applied for children's cases. They have to be fed, clothed, washed, supervised, taught, as we know a lot of in this pandemic, for example, and above all loved if they're to be able to grow up. And their emotional needs can only be fully met within a functioning family. And functioning family doesn't mean one necessarily that's living together in the same household, but in terms of, it doesn't have to be a unit as such. It needs to be an examination of how family life is conducted for this particular child. But the other important principle that you get from this case is that there is that Baroness Hale emphasises that there's a strong public interest in ensuring that children are properly brought up. And actually, you sometimes, if you do a lot of immigration appeals or deportation appeals, and you keep getting sort of negative results, that is a really important principle. That is a public interest, and it's an important public interest, and it is not simply just that there's a public interest in deportation and that's the sort of beginning or end of it, or very difficult to overcome that principle, because the important consideration is what is the impact on the child. I just remind you there, of course it's probably this is just a sort of refresher of the best interest principles that we have set out in section 55 and the Secretary of State's obligations, and that those are set out in Secretary of State's policy in Every Child Matters and Beyond. And so I just remind us there that it requires the duty of a provision to be discharged in a manner that takes into account the need, unless there's a good reason not to satisfy the need and promote the best interests of children, to treat them as being of equal value, and to ensure they have an equality of opportunity in realising their potential. And I think when we just looking at the next slide in terms of Article 3 of the UNCRC, that this is an interpretive principle, and so in all actions concerning children, whether undertaken by public or private social welfare institutions or courts or administrative authorities or legislative bodies, the best interests of children shall be a primary consideration. Not the primary consideration, but a primary consideration. And when you use that principle and look at the UNCRC in General Comment number 14, the best interests is a threefold concept. So it's a substantive right, it's a fundamental interpretive legal principle, and it's a rule of procedure. And again, this is why I think it's important when we come on to looking at the application of post-HA Iraq and beyond, about what processes should be adopted to identify what are the best interests for a particular child, whether the evidence is available, and whose responsibility it is to get that evidence. That is why I just wanted to emphasise that part of the UNCRC in General Comment number 14. And again, just back to interpretive principles, where convention rights under the Human Rights Act are engaged, it's well established that they have to be interpreted and applied consistently with international human rights standards, including the UNCRC. So again, should all assist us with a detailed understanding of how to identify the best interests and how to apply the principle in relation to undue harshness in the context of deportation. I finally just also remind you of the Article 12 principle of the UNCRC, which is that state parties shall assure to children who are capable of forming their own views the right to express those views in all matters affecting the child. Of course, you give due weight to the age and maturity of the child, but in this context, children should be given the opportunity to be heard within an appropriate body, a manner consistent with the procedural rules of national law. So what that means is that, given that in any given case, children whose rights are being interfered with they have Article 8 human rights, and those are being breached by deportation of a parent or parents, that those need to be properly evaluated, and how they're properly evaluated may require them to be individually heard. Ordinarily, and I think Zara is going to come to talk about how we hear from the children normally through the voices of social workers or whatever, but it's important, and this is what happened didn't happen in KO Nigeria, was that there was, even though some of the children were quite old, including a stepchild who was 18, I think, at the time of the original, just so under 18 at the time of the original decision, there wasn't any meaningful consideration of her evidence and any meaningful hearing from her about the impact on removal, on deportation. So just come back to where we sort of started just a few moments ago after setting out the statutory framework, which is that when the court is making a proportionality assessment, or effectively an undue harsh assessment in the context of deportation, the best interests of a child must be a primary consideration. They must be considered first. Of course, they can be outweighed by other cumulative considerations. And in that case, in ZH Tanzania, which was a removal case of somebody who was had no immigration status, in that case the mother, the countervailing considerations were the need to maintain firm and fair immigration control, coupled with, this is the words of the court, their mother's appalling immigration history and the precariousness of her position when the family life was created. But critically, as the tribunal pointed out, the children were not to be blamed for that. And that's why the question of removing the primary, in that case, removing the primary care would mean they'd have to leave with her. But coming back to the point about children not to be blamed for that, if the children are not to be blamed, then it's very hard to understand how the analysis that Lord Carnwath gave undue harshness, having just endorsed ZH Tanzania and Zumbas at the beginning of his judgment, how those two can be married up. And so I think that's where we need to go in for the next talk that Helen Foote's going to develop. But the principles are that ZH Tanzania and Makhlouf and Zumbas are still good law. Do we need a 7 or 9 judge court to unpick those? I'd hope in a way not, because I'm happy with ZH Tanzania and Makhlouf and Zumbas. And actually the Court of Appeal tried to unpick that in HA Iraq. But we just note that, as I understand it, the Secretary of State is seeking permission to appeal in that case. And so sort of watch this space. But to my mind, there's definitely a navigable, successful route in that, even if there is an onward appeal. So I'll leave it there. Thank you very much, and pass you back to Louise and then on to Helen and to Zara, and we'll look at the questions in due course. Thank you. Stop share.
Thank you, Sonali. Next up, we have Helen Foote, who is a barrister specialising in immigration, public law, human rights and nationality law. She appeared alongside Sonali in KO, Nigeria, and also in HICI and others, and the Secretary of State for the Home Department on citizenship. She specialises in complex protection claims on behalf of victims of trafficking, LGBTI refugees, and those fleeing gender-specific persecution. Many of her cases involve children's civil rights. Helen also acts in civil claims against public authorities, including claims for false imprisonment and damages under the Human Rights Act. Helen, over to you.
Thank you very much, Louise, and thank you, Sonali, for setting the context to what I want to say about what we're calling the reasons to be cheerful cases. I'm just going to share my screen now. I hope that works. Okay. So the 3 cases I want to talk about are, well, in the main, the case of HA Iraq, which Louise touched on in the introduction, and then 2 further cases which don't really establish any new principles, but which apply HA Iraq, and which also make some quite useful comments about the upper tribunal's jurisdiction and the flexibility of the unduly harsh test. So we can see from that slide there that everything happened quite quickly last autumn. So HA Iraq was promulgated in September, and then AA Nigeria and KB Jamaica, 2 cases which share quite a few similarities, were heard in October with a similar, although not the same, panel of judges applying the case of HA Iraq in a useful way. So first of all, why is HA Iraq so important and why is it significant? Well, we think it's important and significant because really it's the first time the Court of Appeal has had a look in detail at what exactly the Supreme Court meant, or what exactly it established when it confirmed that the unduly harsh test doesn't factor in public interest considerations. So that, of course, is the headline principle from KO. But what exactly does the unduly harsh test mean? And in a way, it can be argued, or you're probably familiar with this from doing casework in the tribunal, that after KO, even though KO was obviously useful in terms of making sure that factors that weigh against children shouldn't be reintroduced again in the unduly harsh test, after that, there was a bit of a preoccupation with how high the threshold for unduly harsh was. That comes from a case from MK Sierra Leone, which I'll come to in a minute. And we were left perhaps in a bit of a situation where, because of something that was slightly misinterpreted in Lord Carnwath's judgment, there was a sense that if all you had in your case was something which was ordinary or common, so trauma as the result of separation from a parent, that was somehow not enough. And we'll see that HA Iraq makes quite clear that that's wrong. So the restoration of a child-centered approach, which is more realistic, is the reason to be cheerful. So just a little bit about the facts and the provenance of a case involving two appellants, both Iraqi, HA and RA. And although it might not be obvious at first sight, HA is actually the case which was previously RA in the first bullet point there. So the previous guidance case from the upper tribunal, Mr. Justice Lane, which set out to give guidance on what unduly harsh meant. So both the appellants in HA were medium offenders towards the lower end of the spectrum, a 16-month sentence in the case of one of the appellants and a 12-month sentence in the case of Mr. RA. They all had British citizen children. Both cases were successful in the first tier, and then the Secretary of State appealed successfully to the upper tribunal, and the upper tribunal dismissed the appeals. The panel was Lord Justice Underhill, who gives the lead judgment, Lord Justice Popplewell, who appears, as we'll see, in KB and AA, and also Lord Justice Peter Jackson, whose judgment is really significant, I think, and we'll come back to that in a moment. So, as Sonali touched on, the crux of the Supreme Court definition of the unduly harsh test comes from Lord Carnwath at paragraph 23 of KO. And I won't read out everything that's said there. It's well known to you all. But the part of that judgment, sorry, I'm just moving the picture of myself so I can read it all. The part of that judgment which sort of went in the wrong direction is the part in bold there, where he says one is looking for a degree of harshness going beyond what would necessarily be involved for any child faced with the deportation of a parent. And what Lord Justice Underhill does in HA Iraq, at paragraph 42 onwards, is he tries to unpick what exactly Lord Carnwath is saying there and what he isn't saying. And what the court says is that those words in bold about the ordinary effects of deportation shouldn't be taken literally. And to quote, because it's worth reading in full, what Lord Justice Underhill says there at paragraph 44, he says it's hard to see how one would define the level of harshness that would necessarily be suffered by any child. And indeed, one can imagine unusual cases where the deportation of a parent would not be harsh for the child at all, even where there was a genuine and subsisting relationship. The underlying concept is clearly of an enhanced degree of harshness sufficient to outweigh the public interest in the deportation of foreign criminals in the medium offender category. And he goes on to say, this is now at paragraph 56, in relation to the word ordinary. First of all, ordinary is capable of being understood as meaning anything which is not exceptional or in any event rare. That is not the correct approach. See paragraph 52, that's a reference to what's said earlier. You can see the exact reasoning if you look at the judgment, obviously. There's no reason in principle why cases of undue harshness may not occur quite commonly. Secondly, if tribunals treat the essential question as being, is this level of harshness out of the ordinary, they may be tempted to find that exception 2 does not apply simply on the basis that the situation fits into some commonly encountered pattern. That would be dangerous. How a child will be affected by a parent's deportation will depend on an almost infinitely variable range of circumstances, and it is not possible to identify a baseline of ordinariness. And then he continues, I won't read all of that out, to give examples of some of the factors which will be relevant to whether the harshness suffered by a child is undue or not, or sufficient to meet the threshold. The child's age, for example, whether the parent lives with the deportee, the amount of emotional dependence on the parent, the financial consequences of deportation, and so on. So we can see there a very useful confirmation of the fact that just because something might occur commonly, for example, a child traumatized by a permanent separation from a deported parent, that doesn't mean that that sort of scenario, so you might call it a common scenario, that doesn't mean that such a scenario is not capable of meeting thresholds. And that perhaps is the mistake that arguably the tribunals in many cases were making after KO was established. And what he is saying, though, is that there is an underlying concept of an enhanced degree of harshness. It has to be enhanced because it has to be sufficient to outweigh the public interest in deportation. It's not as high a threshold as very compelling circumstances, of course, though, that being the threshold for cases which involve a sentence of 4 years or more. Just pausing there, it's again important, I think, to note that the idea of the height of the threshold, so not just the concept that the test doesn't involve public interest considerations, it just involves the child, but the height of the threshold was approved by the Supreme Court in KO to have been set by, this case, MK Sierra Leone. You'll have seen that quoted a lot, relied on by the Home Office a lot. Unduly harsh does not equate with uncomfortable, inconvenient, undesirable, or merely difficult. Rather, it poses a considerably more elevated threshold. Harsh in this context denotes something severe or bleak. It is the antithesis of pleasant or uncomfortable. Furthermore, the addition of the verb unduly raises an already elevated standard still higher. And again, it's important to note, and this is something which went unnoticed in KO by Lord Carnwath, but in the case of MK Sierra Leone, although the courts made very clear that no one case sets a precedent, a factual precedent for any other case, the facts in MK Sierra Leone involved circumstances in Sierra Leone where at the time there was an Ebola pandemic. The court described the circumstances the children would face were they to go with the parent, as having to go to a struggling, impoverished and plague-stricken African state. And recall that if not in the statute, in the immigration rules, it's necessary to show both that it would be unduly harsh for a child to go with a deported parent and that it would be unduly harsh for them to stay in the UK and be separated from the parent when they go. In fact, and again, this is something that Lord Justice Underhill looks at in HA, which I think is useful. The court found that the threshold was met also in the scenario where the children stayed. And perhaps one can see when you read that part of the judgment that maybe it's become easy, or it had become easier for tribunals to see that it would be harsh and unduly harsh for children to have to go with parents, obviously depending on the country, but Sierra Leone on the facts of that case is perhaps a stark example. And perhaps the courts had become less willing to consider that the stay scenario, which is perhaps the more commonplace scenario, which didn't involve so much physical hardship, but just as much emotional hardship in many cases, as we'll see, perhaps that explained this fixation with a very high threshold and the idea that an ordinary separation may not be enough. And the judgment of Lord Justice Peter Jackson, which is at the end of HA, is really important on this. And if you're going to read anything, first of all, I mean, I think you should read all of HA Iraq, because although it's long, it's just a very, very helpful and illuminating explanation of how we got where we got to in these appeals. But also, if you're going to just read one part of it, read the judgment of Lord Justice Peter Jackson, a family judge, of course, and his judgment starts by summarising the best interests principles, the ones that Sonali has looked at. And then he goes on to say something very significant about the importance of emotional harm. So he says there, I'm going to read it out because I think it's important. There are two broad ways in which it seems to me that a decision maker may inadvertently be deflected from giving primary consideration to the best interests of the child of a foreign criminal. One is by focusing on the position of children generally rather than the best interests of the individual child. The other is by treating physical harm as intrinsically more significant than emotional harm. And he then goes on to say at paragraph 159 that although it's acknowledged by those who work with children that emotional harm is important and there's no hierarchy of harm, despite this, it may be easier for decision makers to envisage the harm that may be done by expecting a family to experience precarious or even dangerous physical conditions than to factor in at full worth the lifelong emotional harm of terminating the relationship between a child and a close parent during the child's minority and possibly forever. Both situations are grim, but for the child, neither is intrinsically grimmer than the other. Provided the decision maker faces up to the reality of the child's situation and gives it primary consideration, the public interest in deportation may prevail, but it will not do to minimize the emotional impact on the child of the severing of ties by reference to the doubtful prospect of maintaining relationships over many years by indirect means only, or by reciting the fact that this is what deportation does. And many of you will read that and be thinking to yourselves, as I am, well, that's very helpful because in many cases, the Tribunal and the Home Office fall exactly into that trap, arguing that there's nothing unusual, there's nothing unduly harsh about a permanent separation. And it's interesting to think about the idea that despite the evidence and principles to the contrary, the idea of physical harm is easier sometimes to grapple with than the idea of emotional harm. So that's HA. And then following HA, we have these two cases, AA Nigeria and KB Jamaica. Both cases where Lord Justice Popplewell, who we saw was in HA, gives the lead judgment. Both cases which were successful in the first tier tribunal before KO, so successful even on the more difficult test, where when the court was looking at unduly harsh, it was looking at parental misconduct. Both cases where the Secretary of State appealed, the upper tribunal found an error of law, remade the decision and dismissed the appeal. And I've set out the summary facts at the bottom there. AA, interestingly, is a case involving a sentence of more than 4 years, 4.5 years for a drugs offence. And in that case, the first tier tribunal had found that there were very compelling circumstances, having previously found, relevant as we know from the case of NA Pakistan, that deportation would be unduly harsh, but going on to find that there were very compelling circumstances. In KB, quite an unpleasant offence, albeit involving a lower sentence than in AA, so a domestic violence offence in combination with an act intended to pervert the course of justice in relation to the trial for the domestic violence. There were 4 British children in that case, Again, the first tier tribunal judge found that deportation was unduly harsh on the old test. Secretary of State appealed. The upper tribunal found that there was an error of law. In that case, as it happens, because the judge hadn't expressly cited the MK Sierra Leone test. So there was arguably a juncture in the case law after KO, but before HA, where the upper tribunal was quite preoccupied, or the tribunals were arguably asking themselves, well, was the threshold applied sufficiently highly? Did the judge direct themselves to the MK Sierra Leone test and so on? So in both those cases, the Court of Appeal found that the upper tribunal was wrong to find an error of law. The first tier tribunal, albeit that not every, in the case of KB, MK Sierra Leone wasn't expressly referred to, the upper tribunal was wrong to find an error of law. And the outcome of the appeal in both cases was that the first tier determination allowing the appeal was restored. And a couple of important points coming from these cases were that the Court of Appeal was quite critical of the upper tribunal finding errors of law in these first tier decisions. And in both cases, Lord Justice Popperwell quotes from that case UT Sri Lanka. So it's the dicta of Lord Justice Floyd at paragraph 19 of UT Sri Lanka. And just to give you the quote from that, although error of law is widely defined, it is not the case that the upper tribunal is entitled to remake the decision of the first tier tribunal simply because it does not agree with it or because it thinks it can produce a better one. And the Court of Appeal there, in the case of UT, quotes from Baroness Hale in AH Sudan, who said, appellate courts should not rush to find such misdirections simply because they might have reached a different conclusion on the facts or expressed themselves differently. So that is the first takeaway point from those two cases. The second one comes from something the court says in KB Jamaica. So recall that obviously when the courts are applying the unduly harsh test, they're not primarily looking at parental conduct because they're not factoring against the children anything that would fix them with the sins of their parents. But of course, factors relating to the parent and parental characteristics can be indirectly relevant to unduly harsh. So here we had a finding from Lord Justice Popperwell, for example, the loss of benefit to the children from KB acting as a role model. So the evidence had said he had rehabilitated successfully and was a good role model for his children. The court found that the loss of the benefit from that to the children was one of the factors relied on by the judge in the earlier section of the decision. That's a reference to the first tier tribunal decision, and stated that that was a legitimate consideration which may contribute to the deportation having unduly harsh consequences for the children. So that is how rehabilitation can indirectly be relevant to the question of unduly harsh. And other factors which were in play in KB, again, just to establish this point. So the Secretary of State had argued that the appellant's activities in caring for the children's grandchildren and efforts to establish a business and so on were necessarily irrelevant to the unduly harsh test. The Court of Appeal found that was wrong and rejected that submission because both factors had a knock-on positive effect on the children. So there we have quite a flexible, child-centred but flexible application of the the unduly harsh test. Okay, so that's all that I wanted to say. I'm going to stop sharing my screen and hand over to Louise, who's going to introduce Zara. Thank you.
Thank you very much, Helen. Zara Hassan is a rising star in the immigration and asylum field. She, after pupillage at Garden Court, she became a tenant in October 2020. and is building a practice in public human rights, immigration and asylum law. She has a particular interest in representing survivors of gender-based violence, trafficking and exploitation, and she's previously worked at a number of non-profit organisations, including Liberty, Southall Black Sisters and the London Black Women's Project. She's currently Vice Chair of the Human Rights Lawyers Association, has in-depth knowledge of legal protections for migrant survivors of domestic abuse, and has given oral evidence to Parliament as an expert witness to the Joint Committee on the Draft Domestic Abuse Bill. Zara, over to you.
Thank you, Louise. Amy, if possible, can we start sharing? Great. Great, so you should be able to see my presentation on the screen now. So I'm essentially going to build on what Sonali and Helen have both really helpfully set out, and just talk a bit about how these principles can be practically applied in deport appeals in the first tier immigration tribunal. Can we go on to the next slide, please? I just thought I would start with this quote because I think really what we have all tried to emphasise today is the importance of this being a child-centred approach. And this is actually from a letter that was written by a child who Detention Action was supporting. And I think it really focuses the fact that children are really impacted, of course, by decisions to deport individuals. And they're often the people who are going to most suffer, but often their views are not materially taken into account. And I think really I want to think about how we can ensure that their voices are heard in these types of appeals. Next slide, please. I thought this was just an interesting and helpful infographic almost from Free Movement, which sets out the somewhat complicated matrix of these types of deportation appeals. It's on the slide, so I won't go through it, but I thought it would be helpful for people to have. Next slide, please. So what I really want to focus on are two things. The first is the application of the HA Iraq principles in first tier tribunal deportation appeals. And I'm going to firstly, within that, look at the approach to the relevant authorities that Sonali and Helen have gone through. And secondly, look at the approach to the unduly harsh test, given that we now have this very clear child-focused approach from HA Iraq. And then secondly, I'm going to think a bit about the evidence relating to children that can be used in the first tier tribunal. Next slide, please. So firstly, the approach to relevant authorities. Next slide. So I just wanted to highlight the importance of succeeding in the first tier tribunal. I know it's easier said than done, but there are two reasons why it's really important. The first is that if you're successful in the first tier tribunal and the Home Office does appeal you, for the reasons that Helen set out that was articulated in KB Jamaica, we now have this authority that makes very clear that the upper tribunal should be reluctant to find an error of law, and it can't just simply disagree with the first tier finding because it thinks it could make a better one. So that's obviously a really helpful authority to have, and if you've set your case up well, it's then helpful to sort of put that forward and ensure that the upper tribunal is not just substituting its own decision for the first tier tribunals. The second reason, though, in relation to that principle in KB Jamaica, is that this principle obviously cuts both ways. So if your appeal is dismissed in the first tier tribunal and you seek to apply for permission to appeal to the upper tribunal, then of course the same principle can be relied on to essentially say that that first instance decision should stand. And so that's why it's really important to make sure that you put forward your strongest possible case in the first tier appeal. Next slide, please. The other point in terms of the approach to these appeals, and I think this is most clearly expressed in AA Nigeria at paragraph 42, is that essentially the judges should not be seeking to express their decisions by categorizing the different degrees of harshness. There is now a very clear legal test that refers to the statutory test, and essentially it's about considering the consequences of deportation on the child, whether that would be unduly harsh, and to evaluate, essentially, in light of the evidence, whether deportation would do so. And of course, every case is going to be different. And in terms of HA Iraq, it's also very clear that we can't measure this objectively. There's no norm, there's no baseline, as has been very, very clearly expressed in that judgment. And so it's really for the individual case to be considered in light of its own facts. So essentially, there's a single statutory test, and the tribunal has to consider this in light of holistically assessing the evidence in that particular case. And that's the approach that we should be putting forwards in light of what HA Iraq has said. Next slide, please. The other point that's made in AA Nigeria at paragraph 9, and obviously the law in this area has been interpreted in multiple different ways kind of prior to HA Iraq, given the problems that Sonali set out in KO Nigeria. But AA Nigeria has now made clear that there's no need to refer extensively to authorities for the meaning or the application of the two different statutory tests. And what AA Nigeria says is that we've got KO Nigeria and HA Iraq in terms of the interpretation of unduly harsh, and we have R on the application of bin loss and NA Pakistan in terms of very compelling circumstances. And obviously, you know, there are going to be different cases where different authorities might be particularly helpful. And of course, we do also have AA Nigeria and KB Jamaica in respect of the application of the law in HA Iraq. But I think there is value to what is being said in AA Nigeria here, in that the whole point is that there is a clear legal framework, there is a clear principle, and that principle has to be applied in light of the factual circumstances of that case. Next slide, please. And so AA Nigeria goes on further to explain the rationale for saying this, and I think that is helpful. And crucially, it says that because there are these infinitely variable sort of factual matrices that will occur in these types of cases, it is important, and I think it strengthens the argument, to rely on the relevant principles and focus on their application in your particular case, and to also keep the analysis of the law focused, and to use this to head off any attempts by the Home Office to detract from these overarching principles. So, for example, the Home Office may try to rely on cases, as they did in HA Iraq, to argue that the threshold is not met. But it's important to reassert the principle that none of these cases can be treated as a touchstone, and a holistic assessment is still required based on the particular facts. No two cases will be exactly the same, of course, and it's important to ensure that the principles are properly applied. Next slide, please. Okay, so the second thing I wanted to look at in terms of the application of the principles is the approach to the unduly harsh test, given the child-focused approach that was emphasised in HA Iraq. Next slide, please. So the first thing to remember is that the best interests of the child is obviously a primary consideration, which Sonali helpfully set out. And therefore, you might want to consider whether it's appropriate to argue these points or plead them at the outset, so that the child-focused approach is at the front and centre of the tribunal's mind. As Sonali also set out, the focus is on the child only. So it's clear in the case law that it's directed solely to the position of the child. There's no requirement to balance the parental misconduct in assessing what is unduly harsh. And as Helen has set out, HA Iraq, AA Nigeria and KB Jamaica have reinforced a properly child-focused assessment and child-centred approach to the test. So it's about the best interest of the individual child, and not the position of children generally. Next slide, please. And Sonali did touch on this as well, but I think that in considering this child-focused approach and in analysing a child's best interest, it's quite helpful to use this threefold concept that's set out in the UNCRC Article 3.1, because it makes sure that you're having a comprehensive and holistic analysis of the best interests of the individual child. So next slide, please. So firstly, considering the best interests of the child as a substantive right. So if we're thinking about this, then what we're essentially doing is considering the relevant test imposed by the principles from this line of authorities that we're discussing today. And the key points are essentially that there's no reason in principle why cases of undue harshness may not occur quite commonly, and that there's no baseline of ordinariness. So we are considering the best interests of the child in light of these principles. So essentially you're arguing, and you're only arguing, that the consequences of deportation would be unduly harsh on the child and therefore adverse to their best interests, taking into account the various and multitude of ways in which a child could be impacted by the deportation of their parent or parents. And in doing this, you're centering the child's individual needs and circumstances. And so even if it's a commonly encountered pattern, which is the phrase that Lord Justice Underhill uses, that does not preclude the situation from being unduly harsh. The next slide, please. Secondly, thinking about best interests as a fundamental and interpretative legal principle. And in terms of the Section 55 duty, Lord Justice Peter Jackson in HA Iraq makes clear that the interpretation of this should not create any hierarchy between emotional and physical harm. And I think that's, for the reasons that Helen said, I think it's particularly important, not just because there's this issue in terms of the distinction between it maybe being more obviously harmful to tribunals, where it's being considered a child could be sent to another country, in contrast to the stay cases that we mentioned. It's also important in terms of assessing emotional as a sort of holistic term, and what that encompasses, and recognizing the ways in which deportation could be unduly harsh on a child's life. And that could extend from psychological, social, developmental, educational, intellectual, and cultural factors. And so I think what Lord Justice Peter Jackson says here helps us, because it shows again that the tribunal has to assess all of these factors holistically. Some may inevitably have a worse impact on the child. So, for example, in one particular case, the psychological trauma to a child could be greater than the cultural impact on a child, but no individual factor is inherently more important than another. And I think that's really important, again, for emphasising that this is an assessment that has to be done in the round. Next slide, please. And then the third, in terms of the rule of procedure. So as Sonali and Helen have touched upon, the Secretary of State for the Home Department is required to ensure that their immigration functions are procedurally discharged in line with their Section 55 duty, and of course the Every Child Matters policy. Now, we'll all know as immigration practitioners, in pretty much every context where a child's right is engaged, the Home Office often look at this in a very cursory way in their decision making. So there's usually one sentence that says, I've come to this decision taking into account the best interests of the children in line with Section 55. But there's no actual analysis of this or evidence referred to, even where available. It's usually done in a very cursory way. And there's certainly no proactive effort by the Home Office to obtain a child's best interests. And so it may be pertinent to think about the Home Office's failure to materially consider the best interests of a child as part of original decision to deport, and with reference to the arguments that you've made in respect of why, had their best interests been taken into account, deportation would plainly be unlawful and indeed unduly harsh. So I think it's important as well to think about the procedural failures of the Home Office in respect of your analysis of the best interests of the child. Next slide, please. And so I'm now going to move on to the second part, which is considering the best use of evidence relating to children. Next slide, please. And I think it's very important, again, to remember here that there is this infinitely variable range of circumstances. I think that's a phrase that really stands out in HA Iraq, because it's very difficult to identify all of the different circumstances and all of the different ways in which a child may be affected. But there are some examples given in the authorities that we've mentioned, and those include the child's age, their living situation, the degree of the child's emotional dependence on the parent, the financial consequences of deportation, and the individual characteristics of the child. And all of these obviously need to be evidenced as helpfully, comprehensively, and clearly as possible in these first-tier tribunal appeals. And I think it's important to think creatively and empathetically about the issues and the impact on the children, and thinking about the types of supporting evidence that may help, both in terms of the child's own situation, but also the role of the parent. It's also important to ensure that any evidence is able to rebut the reliance by the Home Office on assumptions about family dynamics. So we often see that the Home Office can undermine the role of fathers, where the father is the one subject to the deportation order, and where the mother is the one who would remain in the UK. And the Home Office may rely on things like the fact that the mother was able to cope whilst the father was in prison, or that the parents might be separated, and that creates a particular family dynamic. That shouldn't in itself detract from the family relationship between the parent and the child, and the dependence of that child on that particular parent. And so if that's something that you think may come up in that particular appeal, it's important to have the evidence to rebut those sorts of assumptions that the Home Office may make. Next slide, please. So in terms of evidencing the relationship between the child and the parent, so there are three things in essence. It's the existence of the relationship, the nature of the relationship, so that's to show that it's genuine and subsisting, and the extent of the relationship. So in terms of the existence, I've listed some examples of evidence that could be used to show that. So basic things such as birth certificates, GP records, but also things such as whether they're listed as next of kin, their attendance at school parents' evenings, or dropping and picking up their child from school. In terms of the nature of the relationship, so showing their closeness and the subsisting nature of it, photographs, social media evidence, and evidence from the child themselves could be particularly helpful in this regard. And third, in terms of the extent of the relationship, again, thinking about shielding from Home Office assumptions or criticisms that may be made about the relationship. For example, where a parent has spent quite a period of time in prison, the Home Office may say, well, how can they have a relationship if this parent has been in prison for a long period of time? If there are records of that child visiting the prison, or any way you can evidence how the relationship continued in that period, that would be particularly pertinent to produce. And if the parents are separated and the child has not been habitually living with that parent for an extended period of time, family court orders in terms of child contact may be particularly helpful, but remember to seek permission from the family court before putting those documents to the first-tier tribunal. Also, in those sorts of contexts, evidence of their living situation may also be helpful. Next slide, please. And then in terms of evidencing the impact of deportation on the child, and that's considering both the parent's role in their life and their own personal situation, I've listed here a few things to consider. So their education, their social circumstances, their emotional situation, any physical needs, psychological needs, developmental needs, and cultural factors. And I've listed there a few examples of the types of evidence that could be adduced in such cases. But I think it's important to say, obviously, this is not an exhaustive list. And as I said at the outset, it's important to think creatively about these types of cases and about the evidence that you could use. But just to talk through a few of them, in terms of education, of course, reports from education institutions are important, or anyone else who has some sort of responsibility for that child's educational needs. In terms of their social circumstances, an independent social worker's report is usually extremely helpful, and where you can ensure that they are comprehensive, they can address quite a few of the issues that you may want to raise and that you may want to point to in terms of the impact on the child. Also, in terms of their social needs, if they're engaged with some sort of youth support or youth centre, evidence from those groups could be of use as well. In terms of their emotional needs, again, their own testimony might be extremely important here, but also expert evidence from a social worker or from a medical professional. In terms of their physical needs, of course, GP records, medical records, but if they have a particular physical issue or a disability of some sort, then expert evidence from professionals who are treating them for that would be particularly important. And that goes for psychological or psychiatric evidence as well in the form of an expert medical report. In terms of their developmental needs, school reports that focus perhaps on their behaviour or their behavioural needs, and that can be similarly reflected in a social worker report. And then in terms of cultural factors, so where, for instance, they come from a family where the parent who is subject to deportation is from a particular cultural background and the other parent is from another cultural background, you could think about the impact of separation on them losing that cultural influence in their life, whether that's religious or whether that's community-based. And I've listed the types of evidence that could be considered in that kind of context. Make sure that all of these key factors are addressed in a detailed witness statement from the client and also from family members, which focus on the impact on the child. As I've said, expert evidence is usually essential in these types of cases to demonstrate the clear impact in terms of the child's needs. And where they have particular vulnerabilities, ensure that you have got expert evidence where required. Next slide, please. And as Sonali mentioned, Article 12 of the UNCRC makes very clear that a child who's capable of forming their own views should be afforded the right to express those views freely in all manners affecting the child. And so it's also pertinent to think about letters from the child if appropriate or possible. And if the child's not able to, is at an age where they can't write a letter, anything else demonstrating the child's own views, whether visual or whether in their schoolwork, if they've done something for school that mentions the parent and the relationship they have with the parent, that might also be helpful evidence of the child's relationship and of the child's situation. Next slide, please. And in these cases where it's being considered whether the child could go with the parent who is subject to deportation, country expert evidence might be necessary and helpful. And I think the country expert evidence in those sorts of cases does need to consider, will the child's rights be protected in that country? Will the parent be able to find employment in that country? Will they suffer discrimination or other forms of harm? If they have any health needs, will there be adequate medical provision to meet those needs? And also if they have any other vulnerabilities that would be particularly impacted in that country, then to consider that as well. Next slide, please. And this is just an image that I thought I'd end with. It's a drawing from a child whose parent was subject to deportation, that was submitted to the court in the context of their of those proceedings. It's from Detention Action, and it makes very clear what that child's view is. I think it picture really does say everything in this context. And I just wanted to end with it because I think it's an important reminder of what we're fighting for. We're fighting for the child's right to have their parents with them, to enable them to have a stable and loving environment to grow up in. And we are trying in these appeals to ensure that the focus is on the child's life, on the child's circumstances, and on their experiences. And so it's crucial that we're centering them in our arguments, orally and in writing, that their needs are voiced in these appeals, and that their voices are evidenced through all of the ways that I've suggested, and any more that we can think of sort of collectively. So thank you very much. And that's everything I wanted to say. Looking forward to the questions.
Thanks very much, Sarah. Can I just draw to people's attention something that's been put in the chat by Anna Skian about a workbook for younger children to provide information about their lives, which can be used in the context of these sorts of proceedings. And also in the Q&A, there is reference to a book by, the reference was provided by Smita Bajaria, and you'll find that in one of the answered questions in the chat, which is about maternal sentencing and the rights of the child, which is looking at enforcing children's rights, specifically where deportation is an issue. And I'd just like to bring people's attention to one other case before turning to Sonali, which is the case of unduly, which is a judgment of the 24th of November 2020 in the ECHR, which is a case looking at a sentence of 5 years and 6 months, so over the 4-year threshold, which may be about to throw the cat amongst the pigeons again, because the ECHR have looked at that from the context of children's best interests. And interestingly, they look at it whilst recognising the legitimate interest in deportation, whether it's nevertheless proportionate and necessary. And this concentration on necessary as an Article 8 principle seems to be gaining some ground in the ECHR, not just in deportation type cases, but generally. And they conclude in that case that having regard to the findings made by the tribunal, which were just under the immigration rules, to find that although it was unduly harsh, there were no very compelling circumstances over and above the case being unduly harsh, and then dismissed the appeal for the father, but not for the children, having found that would be an unduly harsh consequence for them. And so they held that you still have to look at the Bultif, Una and Maslov criteria, which we've sort of forgotten about a little bit along the way. And applying those criteria, they decided that the Article 8 conclusion by the tribunal was wrong, and that it would be unduly harsh and disproportionate to the legitimate aim pursued, and as such was not necessary in a democratic society to do that harm to children in the light of that offence. So I just raise that as another thing that people might want to consider. Finally, Sonali, do you want to come back at the end?
Oh yes, I've got a slide. I think there's one more slide. I think that Amy is going to share that slide. But if not, oh, there it is. It's the very last slide on the pack. So this is where I would like to think about where we go with these principles. So we've got some great principles refining what was said in KO. HA RAC sets out a really coherent analysis of how how those principles should be applied. I don't think our major objective now is to persuade, if that case gets as far as the Supreme Court, to say that KO is not in conflict with HA. HA is just expounding how those principles should be applied. So the next question then is, how do you and Zara touched on this as well in her presentation, how do you get children's rights recognised in the framework that we have, either in statutory appeals or in judicial reviews. They are Section 7 of the Human Rights Act. They are Human Rights Act victims, and so their rights need to be taken into account. Now, ordinarily, those are taken into account through the framework of an appeal. So says EWCA Civ, which was back in 2007, 2008, in a context of removal, which was ordinarily the rights of the children, parent and minor children would be considered at the same time. But I sort of think there's been an evolution from there, which is that, particularly in the context of the statutory framework, which is where I started, which is the statutory public interest considerations, that actually where Parliament is saying, well, this is how things are going to be decided in respect of you, but not with you or with reference to you, that now that we've got an argument for saying, no, as a child, I need a remedy. And if that appeal isn't going to be a sufficient remedy, because it's not going to hear from me, I'm not going to look at things from my point of view, then I want to bring a human rights claim. And I don't think it's outlandish at all to suggest that children should bring their own Human Rights Act claims along with the parent, and then the court was forced to look at them from the child's point of view. We're trying that in a judicial review that we're doing in a case where one of the Jamaica charter flight cases, and where the children have brought their own claim for judicial review because the father had an appeal, but he never exercised the right of appeal, and so the children brought a claim. And that claim has got to be determined. Now, the Secretary of State, of course, is desperate to settle that case, because from her point of view, she's saying, well, you had a remedy and you didn't exercise it, and I can agree it now. It's a fresh claim. So, but the father, this is about the children's claim. Who's going to determine that? And actually, within the context of judicial review, as we know, the court can make its own decision on proportionality, and there needs to be a mechanism by which the claim can get off the ground and can actually be litigated, and how you do that discreetly from their parents now is a realistic and real question. Do they require separate representation? You may have cases, where children, it's a bit like the McLuth scenario, but except the facts weren't good in McLuth, where you've got the father, the mother, and the children who, if the father and the mother are living separately, or mother is withholding contact, or other way around, then the children's rights are not going to necessarily be easily identified through the father. So back to hearing from the children, both Zara touched on that as well. And what can we learn from the family court? If this was family court proceedings, the children would be represented, the father would be represented, the mother would be represented, the local authority would be represented. It seems astonishing to me that in a deportation that could lead to permanent separation of parent and child, or child from parent, that the children you don't hear much about them at all. And so when I say revisit EWCA Civ, I think refine is what I really mean. Because what we now have is a lot of history. But before HA came out, so many FTT judges are so used to thinking, you can't win, it's unduly harsh, but you can't win, back to the kind of Unane approach, that there's a lot of unlearning that has to be done by the FTT in the first tier. And so whilst somebody asked a question in the chat which was, well, should everybody win then? And actually I do say that when the 2014 Act was introduced, as lawyers we were thinking, well, if you're in the medium category, yes, you do win. It's hard to win in the very compelling category, but in the medium category you should be able to win, as long as the whole family can't be expected to go to wherever to the proposed country of deportation. And ordinarily, or quite commonplace anyway, you've got British citizen children, or children who have been here for a long time, and so you wouldn't ordinarily be requiring the children to go as a whole, albeit that even in KO Nigeria, the tribunal had found that some of the children could go, but not the eldest child. So I do say that if you properly apply the law as it was intended, and rather than this distortion of where things have ended up by twisting the principle, that the medium category offender, the 4-year threshold, was chosen for a purpose, and it should be cases where they are winnable. We used to win those cases before the 2014 Act quite often, quite routinely. And as I pointed out, there's nothing in the Act that downgraded children's best interests. So as far as I'm concerned, yes, that should be the case. So I'll stop there and say let Louise deal with some of the questions. We've got 250 people on the seminar and a lot of questions.
Thanks, Sonali. There was one that was in the chat that I think you wanted to answer live in any event, which was possibly the one that you've just answered about whether we win all of the cases. I have a question from Mike N about how you think the unduly harsh threshold will be applied in a case where the parent is not the primary carer of the child, but has been involved in the upbringing of the children through financial maintenance and contact potentially in difficult family circumstances. So I think one is generally, and the other is in circumstances if contact is currently blocked.
I mean, I think I partly answered that, I think, in the chat, which is to say that if there's a question mark about contact, what you really need to do is to get the family court to do that assessment, because then you've got all those the evaluation done in the appropriate manner. That was what happened in McLouf. It's just that in McLouf, the court said no, actually, there doesn't need to be contact, and there's no real relationship here, and the father's trying to use the children as a vehicle to get his case sorted. So if you don't have contact and you're seeking it, that's the better way to get the family court to intervene. I know the family court have a no order principle, but at least you might be able to get the reports done that way. But ultimately, it will still come back, as Sarah said. I'm happy to let Sarah or Helen answer any of the questions about. It is about does the evidence that you managed to get to garner show about the impact on the child of withdrawing the financial support, or it not being available, or not being able to develop a relationship with the father, if that's been prevented at some parts, either by the criminal incarceration or by family circumstances, social family domestic circumstances.
It's going, just to briefly say something on that, obviously, without wanting to sound trite, it's going to depend on the individual relationships concerned and the individual evidence. And there may be cases where parental relationship has been very difficult. There hasn't been much contact, but that nevertheless the permanent separation that would ensue in the event of a deportation would cause harm to the child. It's just, I think that the sort of spirit of the Peter Jackson judgment is that you can't preempt these things or make generalizations about the impact on individual children.
There's a question in the chat that is asking if you're saying that findings of the family court ought to bind the immigration court. I think that might have been directed at Sonali.
Hang on, sorry. Yes, I mean, it's much more likely that the family court is currently in the structure that we have. The family court just is better placed to make those evaluations than the immigration court, because all the parties are represented, and there's a proactive duty and inquiry as to getting the evidence. So they're not necessarily binding, but if you look at Baroness Hale's judgment in McLouf, she says, given all that had happened in McLouf, with all those inquiries having already been made, she didn't find there was anything else left that the Secretary of State should have done, or that the court should have done. So it may not be binding in the strict legal sense, but it is a process. Back to Zara's point about a process point about how to find out about the best interests. We just simply don't have that currently in immigration, within the structure of immigration appeals or judicial reviews, where we can routinely get that. So that's how I would answer, to say that that's probably the better forum to get that if you've got no other way of getting it. And I think someone says it is only persuasive. I think that's right, but it may be, in the absence of anything else, quite significantly persuasive.
And Sarah, do you want to come back on the other question, which I rudely interrupted in the middle of because I was trying to look at 3 screens at the same time and deal with a cat?
Sorry, I think you froze there for a bit. Was that on the question? Sorry, I was just thinking about something in terms of the second question as well.
Go for it on the second question.
I was just going to say that in terms of the considerations made by family courts, I think it's, obviously it's important that in some circumstances, those determinations or family court orders can be quite determinative of a particular issue in terms of the relationship between the child and the parent, how often contact is happening, what the nature of that contact is, how long it's been going on for, in cases where the parents aren't together or there's some sort of complexity to the family dynamic. But it's also important to remember that where contact between a parent and a child isn't entirely reflective within a family court order or family court judgment of the relationship that your client is telling you is there, for whatever reason, it's important to then couch that in other evidence and to show that. So sometimes it can be determined really helpful, but sometimes there's a need to go beyond that, where you think that the family court hasn't quite got it right in your client's case or doesn't quite reflect the actual family circumstances. But I think in terms of its persuasive value for the first tier immigration tribunal, it's obviously a really helpful way of showing what that child's situation is and the relationship that they have with the parents. So yeah, that's what I was going to say on that question.
And Robert Berkhamshaw has written in the has raised the issue of cases where the parent remaining in the UK may have a negative or malevolent impact on the child. And this is something that Sonali and I have talked about in terms of the potential conflict between children's rights and resisting deportation in some of the cases that we've looked at. Does anybody on the panel want to discuss that issue?
I mean, I think... Oh, go on, Sarah, go.
I was just going to say very sort of briefly that I think even in a circumstance where the child's best interest might not be best served by living with that parent or seeing that parent all the time, doesn't mean their best interest would be served by that parent being in an entirely different country. And I think ultimately kind of my general perspective is that we have other systems within this country that safeguard children in different ways. It's not for us to really consider whether the deportation system is a way to safeguard a child, and I think ultimately it's not going to be. So I think ultimately that's sort of what I would say. It's really it goes beyond what the immigration system does, really.
Sonali, do you want to come in on that?
Yeah, all I would say, I was about to write that into the chat, was that if the evidence shows that in fact it may be that you won't win that case, even if there are positive overall benefits of the parent remaining here, even at a distance or contributing in some way, but that's not for us to decide. What we want to do is get the evidence out in relation to father or parent and the children, and if there's a conflict between the two, then they should be separately represented. And that comes back to the point, the Bioku Betts point, and actually it came up in EM Lebanon, I think, as to whether that there needed to be separate representation of parent and child there. That was a removal case, and ordinarily it says that we don't you wouldn't need separate representation. But if there is that conflict, then, as in the family courts all the time, then all parties get separate representation. And I think it's difficult to persuade. I think somebody, I think Sean put in the chat that or in one of the Q&A that Sean McLaughlin, that he had got separate representation for children in a judicial review, and I think that where circumstances require it, that we shouldn't be hesitant to recommend it. And but there is a learning from our family colleagues that we have in Garden Court and other chambers, of course, and that's and that is something I think we should be creative about. Identify where children need to be heard separately, and then and represent them, because that's what they deserve, and that's what the Human Rights Act requires.
Thanks, Sonali. I think there's a really interesting issue about Article 13 and effective remedies for children. Very conscious of the fact that time is now up, and some people are starting to drop off, but if there are any more questions, the panelists are willing to stick around for a few more. At the moment, I'm not seeing any. So unless there's anything further that any of the panel wants to add as a last word.
Just to say, we will be sending out our notes, so emailing those to all attendees, and so you don't have to scribble things down frantically.
And then finally, thank you very much to the panelists, Sonali, Helen and Zara, and to everybody else for coming, and we'll make sure everything gets sent out to you after this session. Thank you. Bye-bye.
Great.